What I hope to accomplish today is to give you an overview about some of the critical aspects of estate planning that you should be looking at, because this affects all people in many different ways. And I'll try to address as much as I can within this hour. Next slide. You know, there are various estate planning documents that are relevant, and I'm going to try to cover some of the highlights of the critical ones that I see. The first document I want to talk about is a power of attorney. What is a power of attorney? A power of attorney is me giving another person the ability to do what I can do, whether it be to specifically as a special power of attorney for one item to sell my car. If I was in the military and I had to go overseas, I might give somebody a special power of attorney so they can sell my car. There is also what's called a general power of attorney, which means I'm giving that person the right to do everything for me. And if you think about it, that is a necessary document in many cases, but it's also something that you should be very watchful as to who you give such a power of attorney to. I might add that power of attorney can be operative for whatever time period there is named in the power of attorney. It could be open-ended, it could be for 1 month or whatever you say. But on death of you, the individual, that power of attorney stops, meaning that even though somebody has a power of attorney, once you die, they no longer can use their power of attorney for any given reason. The next item I want to talk about is something that unfortunately is much more prominently in the news these days, the healthcare directive. What is that? That is a document, in particular in California, there are very specific issues that need to be addressed. But that document is what you say you want medically if you're unable to make decisions for yourself. You're giving the other person the ability to make decisions all the way up to, quote, pulling the plug or whatever else it may be. But those are things that you should discuss with your family and your doctor, etc., before you delve into that. The next two things really are the most critical parts of estate planning: the will or a trust. What is a will? We know that on death, in a will, you can describe who and where and when you want your assets to transfer to. So a will is a document that does that for you. And a will by definition means that the will that's there on your death is given to the court, and the court has a probate proceeding. The significance of the probate proceeding is what? The probate proceeding is really the court changing the title of an asset from my name into the name of the beneficiary in my will. So the will does not automatically do that. It takes the court action to have that happen. And obviously, that's very, very important. A trust is a document different than that in many ways. A trust can be set up today, and the trust itself has a trustee. Typically, I'm naming myself as trustee, and therefore the trust might say the Stan Smiley Trust. When it's the trust like that, I have the ability to make changes to that trust. The reason you set up the trust is that on death, the successor trustee to me, whoever that I name, can immediately, moment one after my death, follow the provisions of the trust and do what otherwise is required in the trust. Next slide. A trust really comes in two different flavors, so to speak. One is called revocable and the other is called irrevocable. If I create a trust today and I create something that's revocable, that means that I, who create the trust, tomorrow could change that trust at my will and do whatever I want. It becomes my alter ego. Whatever tax ramifications there are for assets in that trust, it's reported under my own personal Social Security number so that it gets reported on my tax return. And as I said before, I have the ability to make any change I want up to the moment of death. What's the impact on probate? Well, if you have a trust, then the assets of the trust really are not part of the probate proceeding or the court proceeding. And that becomes important. One of the reasons you might consider doing this is that in a probate proceeding, like in California, the court in California has the ability to change the title of any assets that I own anywhere in the world. But for real property, California can only change title to the assets in California. So therefore, if I lived in California and I had a condominium in Colorado, the probate proceeding here could not make that change. Therefore, you might consider having a trust and have the property in Colorado in that trust. So the moment I die, whoever is the successor trustee could then sell that property as they wish. Otherwise, it requires a separate probate proceeding in Colorado to make that change. And if you think about that, in terms of sale, if there are two units in Colorado, one that can be changed because it's in a trust and the other one's not, the one that's not in the trust could take months before the person or the executor of the will can in fact sell it. So it's advantageous when you have property out of the state to have a trust. Now, I keep talking in terms of the revocable trust. There is a difference between that and an irrevocable trust. A trust on my death that was revocable becomes irrevocable, meaning that it cannot be changed. It also becomes a separate tax identity. It gets a separate tax ID number and pays taxes separately, much like a corporation. It's a totally separate identity. It can be created during my lifetime or even at my death. And as I say, the tax consequences are such that because it's a separate identity, it is therefore taxed at the trust rates. And therefore, that's something to consider. You know, I've always made the comment that when one has more than two children, there's typically a problem with one of the children. And I wish I kept track of this. I will tell you that I come from a family of two, myself and my sister. I had the opportunity in law school to do research work for the dean of the law school. And I used to once a month go over to his house. He had 11 daughters. And I was marveled at going to dinner, sitting at a table with that many people. Then his wife had a 12th child, which was a boy. My comment is, I have not kept track with the dean, but I assure you that with then 12 children, there's a great probability that one of those one child is a bad child, bad in the sense drugs, alcohol, gambling, whatever else it may be. And parents typically are concerned with how do they make it work properly for the quote bad child after they're both gone. And my comment to that is something that I've called the incentive trust. An incentive trust has no legal definition. It's really a Stan Smiley creation. And what do I mean by that? The parents can sit down and make a list of all the bad habits of that quote bad child. And they could say that if the child is involved with drugs, if they remain sober for such a period of time, they get certain dollar amounts from the trust. If they're a spendthrift and they just spend a lot of money, then you could say that for every dollar that they earn, they get 50 cents in a dollar from the trust. You can delineate going forward in the future what the trustee is going to do with those assets to that bad child. And it's very creative for the parents because they make a list of all the bad habits, and an attorney can just take that list and drop it into the trust. So it's something to consider in that regard. You know, individuals have often asked me, if you have 3 children and one's a bad child, why can't the 2 good children get more money? In other words, get 50% each instead of a third, and therefore provide for their other sibling as they see fit. Well, let me tell you, my practice and history tells me that doesn't work. Why? Because the spouse of those 2 children typically says at some point, why am I giving money to your sister or brother going forward in the future? That's ridiculous. So it creates a lot of strife within the family. But again, the incentive trust is something that can be considered or should be considered, and you can talk to your own financial advisor if it's applicable to yourself. Next slide. You know, it's interesting. When I first started at Cetera, which is 1997, the total amount of federal exemption for estate tax was a number of over $600,000. And we know that in California, even back in 97, most homes were valued more than that. So individuals really were subject to federal estate tax. Now, in 2025, the federal exempt number is $13,999,000. And in 2026, it will go to $15 million. I might add, in California, there is no state estate tax. So it's only the federal number that you're looking at. And I might add that on the death of one spouse, the surviving spouse, to the amount that's not being used, it's portable, meaning that the surviving spouse not only gets that magical $13 or $15 million number themselves, but gets what's left over from the first spouse that wasn't used. And I might add, again, not so in California, but in other states it's true. Other states have much lower thresholds where estate taxes kick in. So therefore, if you have property in other states, etc., that's something you should be very much aware of. Next slide. Let me talk a little bit, which is very confusing to most people. You know, most people think that a qualified plan like a 401k and an IRA are treated the same, where they really have different derivation. An IRA is treated differently because it's really a creature of state law. It's a trust, but it's subject to state law. Whereas a 401k is subject to ERISA, that's subject to the Internal Revenue Code and congressional action, and it gets special attention. An IRA in bankruptcy is protected only up to the amount of $1,711,975, and that's important to recognize. A 401k, nonetheless, in bankruptcy is fully protected, so it has a different feature entirely. I might add that there's a difference between bankruptcy and creditors. Let's use this example. O.J. Simpson. O.J. Simpson had a NFL qualified pension plan retirement, which I think he was getting about $250,000 each and every year. Because it was a qualified plan, his creditors, which ironically were his own children in part, they could not, with their judgment, reach that custodian to take money from that qualified plan. Only when the money is paid out of the qualified plan could they try to get that money from his checking account, etc. Whereas that's when you have a creditor. As I say, in bankruptcy, that would have been fully protected. And again, I say to you that an IRA is subject to state law in terms of what that means. And it's interesting. In the United States, certain states say that an IRA is fully protected from judgment creditors, and other states say it's not protected at all. Only California, and you'll chuckle at this one, has the unique feature of saying only so much of the money in the IRA as is reasonably necessary for a retirement is protected. So you could have a judge in courtroom A with exactly the same facts as a judge in courtroom B, and each one of them, and with the same facts, to determine that one IRA is fully protected and the other IRA is not. So that's an interesting dilemma, if you want to call that, here in California. Next slide. I talked before about the estate tax. Now, here's the game plan or strategy that's always been in effect. Certainly back in 1997, then and still now, any dollar amount that I own on my death can go fully to my surviving spouse, and no matter how much money I have, even if it's above that federal number, if it was $20 million of money, that money going to my spouse is not subject to any estate tax because there's a special provision that says between spouses, there's unlimited marital deduction. So no matter how much money goes to my surviving spouse, there is no estate tax. But the game plan has always been that you want to carve out on my first death the most amount of money that can go to other than my spouse, to my children, without estate tax. So back in 1997, I told you that number was $600,000 of money. So what I was always going to do was, on my death, I would try to make sure that $600,000 of money was going directly to my children, and therefore be out of my estate, and my spouse get the balance of the money. So that's called a B trust, meaning that the surviving spouse gets in the B trust what's left over. And in that case, all they have is the right to get income from that bypass of B trust, but they do not own and do not have the right to delve into the principal. And again, when you have numbers higher than that estate federal number, that makes sense. So back in 97, if you had $2 million of money, then you'd want $600,000 to go to your heirs, no estate tax, and the balance to go to my surviving spouse, no estate tax there either. And therefore, the surviving spouse only has that net number at her disposal. In that B trust that it was going to my children, we'll say she would have it as a only rights to income at that point. And that's a problem. The difficulty is that because the way this is set up typically in most estate planning documents by most attorneys, they fund that B trust first, meaning that they say the B trust is created to fund the most amount of money that could escape estate taxation. So let's say in 2026, the magical number is $15 million of money. Let's say right now, you and your spouse have a total of $800,000. If you have that formula in your estate planning documents, what that does is on your death, it causes all that $800,000 to go into the bypass of B trust, such that your surviving spouse only gets income from that with no opportunity to get money from the principal. And my point to you is that it's incumbent upon you to look very carefully at your own estate planning documents to see if what I just said is correct, meaning that the bypass trust is funded first, because if that's done, then it's imperative that a change be made before the first death, because once that first death occurs, you're locked in, that becomes irrevocable. And so that's very, very important to look at. And I assure you that, again, almost every attorney did it that way. Going forward, an attorney would be very clever in creating an estate document such that you'd have different alternatives. Saying if the federal estate number was so much dollars, it would be done one way or otherwise, etc. But again, I'm telling you that older documents certainly have the wrong formula and to the detriment of your spouse. And I'll give you a very concrete example. Not too long ago, there was a husband and wife who had, I think, about $2 million of assets, and they were age 30. And I happened to see the document and I pointed it out to them, and they made that change. Sure enough, within 2 months, the first spouse died at age 30. What that meant was that all that money would have gone into the bypass trust. So the surviving spouse did not own that trust, did not have rights to that trust, but only income, and could not dip into the principal. So because they made that change, that saved the opportunity to give the surviving spouse, more opportunity, more useful. And at age 30, they had probably 50 years of life expectancy. They made all the difference in the world. Let me also explain to you that one of the unique features of dying, if you want to call it that, on death, your assets get a stepped up basis. What does that mean? If I have an asset, let's say I have a mutual fund, and my original cost basis was $20,000, and today that mutual fund is worth $100,000. When I die today, whoever inherits that mutual fund from me doesn't start with my $20,000 basis, but has a basis at that point. I think I used the example of $80,000. So therefore, if they sold it the next day, there'd be no tax because they're selling it for the same fair market value that existed on my date of death. And that's what we mean by a stepped up basis. In a very strange and quirkish way, in a community property estate, there is a very unique feature. Again, in most states that are not community property, only the portion that is involved with the actual decedent gets a stepped up basis. But in California, as other community property states, both halves get stepped up basis. So all the assets get stepped up basis, which is very, very significant here in California. Next slide. Let me give you a couple of different strategies that really are very, very useful and you might consider. I used the example a moment ago of a mutual fund. We had a cost base of $20,000 and today is worth $80,000. If I sold the mutual fund today, myself personally, I would pay tax on that gain of $60,000. I can take any asset that I own, that mutual fund or any other asset, and I can donate that asset to what's called a charitable remainder trust. And what does that mean? It means I give the asset to the charitable remainder trust and they sell the asset. Because they are tax exempt, when they sell it, there's no tax consequence when they sell it. What do I get in return? In return, I get an annuity measured by the full amount of money they got on the sale. So if they sold it for $80,000, I in return get perhaps a lifetime annuity of $80,000. And yes, as I get annuity payments over time, I will be incrementally taxed for receiving those payments, but at least I'm not being taxed on the original gain that there was in that mutual fund. And I'm using a small number, but really that number can be very large. You could have a business with a low cost basis and it's now worth a lot of money. If it's put into a CRT, there's a huge tax advantage to do so. What are the negatives? The negatives are that when it goes to the CRT, that CRT at my death, the money must go to a bona fide 501c3 charity, meaning that I cannot control where that money goes. It can't go back to my heirs at all. So I lose the ability to have that asset. And so there's different formulas that are worked out. And when you figure this out, what you do is you end up giving, as I say, the remaining going to charity. And then the expected value on your death must be at least 5% of the asset value. And over time, I'm getting an annuity payment. Each of the annuity payments, as I say, is going to be taxed. If I live to be 120, I beat the system because I got a lot more money in the annuity. If I die the next day because I get hit by a beer truck, bad move. The way this works in its optimum, you typically take a small amount of that annuity payment regularly and you buy back an asset that you gave up. In other words, in my example, I gave up a mutual fund that was worth $80,000. So what I do is I would have my annuity quarterly, monthly payment, whatever I have, buying a life insurance policy so that when I die, My heirs get the life insurance, both income tax free and estate tax free. So the concept of the CRT is such that you avoid the immediacy of taxation. And as I say, the bigger the gap difference between the original cost of the asset and today's fair market value, the greater is the effectiveness of the CRT. And it comes in different flavors. A charity remainder annuity trust is a trust that will pay me annuity payment based upon a fixed amount being distributed annually. A charity remainder unit trust is paying instead a fixed percent of annual distribution. And then it's called a net income makeup trust, which basically creates a pool of money that I could draw from over the years in the future. So this is a very, very clever way to take assets that have significant growth in them and avoid the taxation that you would otherwise have on sale. Next slide. An irrevocable life insurance trust is analogous to what I said before, because what am I talking about? I today could cause a life insurance policy to be put into an irrevocable trust. When I do that, that trust, when it pays out the money to the beneficiary, is paid out to the payouts are income tax free, and because it's not part of my estate, it's irrevocable. I've given it to this irrevocable life insurance trust. It is out of my estate, and therefore it has great benefits. And certainly the death benefit, as I say, is estate tax free and income tax free. It's a very clever way to take money out of your estate, have it go to your heirs, and let it go on your death to them, and estate tax free and income tax free. I should have added before on the CRT what I failed to mention. The expected amount of money that's going to charity on my death, by my age, whatever my age may be, if I'm presumed to die at age 85, the formula that's used determines how much money is expected to remain in that CRT at my age 85. And that dollar amount is given back to me as a charitable deduction that I could use over the years going forward. You never go back and recalculate. So even though it's a high number, as I say, I get a charitable deduction immediately that year for that amount of money. Next slide. Unfortunately, COVID had a lot of certainly negative consequences. But one of the things that it showed, at least from the calls that we get, is that everybody's interested in getting long-term care coverage. And as I say, COVID enhanced the desire to get that coverage. The problem is, that's great to have the coverage, but the cost of payment is very, very significant. Here in California, it's astronomical, and frankly, in other states, equally is significant. There is a unique feature of the Internal Revenue Code that allows the following. If I have a non-qualified annuity, which is an annuity that I create and that says it would pay me an annuity at my age, say 65. If I do not annuitize that contract, meaning that if you annuitize the contract, you start getting a fixed amount of money over time at age 65. If the money is sitting there before I'm 65 and I want to take a distribution from that annuity, unfortunately, I pay a very significant amount of tax because I don't get dollar for dollar out tax free, and it becomes very, very negative from a tax standpoint. There is a unique feature of the Internal Revenue Code under Section 1035 that says, if I take money directly from my non-qualified annuity before I annuitize it, let's say I'm age 50, and I take the money out, and the money goes from that particular annuity carrier directly to pay the premium for the long-term care carrier. It doesn't go through my checking account. It goes from one carrier to the other carrier. That amount of money goes at 100 cents on the dollar tax-free. It's a great way to pay for long-term care. I might add that statistically, most non-qualified annuities do not get annuitized, and more than 90% never get annuitized. And so therefore, there's a great way to start paying for long-term care. And you can take out money each and every year, assuming you have enough money in the non-qualified annuity to do so. And this could also work for a new long-term care policy, certainly. But of course, to get a long-term care policy today new, I have to be health insurable for that to happen. But this is one that can be very, very significant for you. The next thing I want to talk about is a very unique feature of the Internal Revenue Code in Section 1202. I've often joked about the fact that many of us have children who are still living at home, working on a second, third, fourth college or a graduate degree, and they don't know what they want to do with their lives. Under the Section 1202, if you create a C corporation today, you create a new business, and I could even borrow money from a Small Business Administration loan, and the business must be worth less than $50 million to start. If I own that business and that stock for 5 years and 1 day, and at the end of 5 years and 1 day, I sell that at that point, whatever gain took place in that stock, because the business was successful, I pay no ordinary tax, no capital gain, and no alternative minimum tax. So all the gain is tax-free. And only with the recent tax legislation that was passed in July was the 5-year 100% rule somewhat changed. And the rule was changed such that instead of 100% in 5 years, if I hold that stock for 4 years, 75% of the gain is forgiven. And if I hold the stock for 3 years, 50% of the gain is forgiven. And that's very, very significant. And again, if you have an entrepreneurial idea that what you might want to do, and you parlay that with a small business loan, you're not even putting up your own money, and your children or whoever are not putting up their funds. And if the business is successful, what a windfall to them. In other words, they will get all that money, the gain tax-free when the business is successful. I might add, ironically, the reason this is put into effect, the government at the time was concerned that they wanted to see unemployment go down to a lower number. And they felt that they would be willing to walk away from the benefit or the lack of benefit of getting tax money in the future to having more people employed. The assumption being that my new business could only be successful if I hired new people to run that business, because the more I hired, the more successful the business would be. So that's something to consider. Next slide. You know, I've done a lot of speaking over the last 30 minutes or so. Let me throw this out, if I could, to questions that you have. I might add, I just highlighted a few points, but again, it's incumbent upon you, certainly the estate planning arena, to talk to your own attorney, to talk certainly to your financial advisor as to how this applies to you. And it's become extremely problematic when you have children from a first marriage, because I'm just telling you, it's my observation that when someone gets divorced, they typically remarry somebody of a generation who is of the same age as the children from the first marriage. And that creates a lot of strife between the children from the first marriage and the new surviving spouse. So all this is in play, and this is something you really need to discuss with your financial advisor. And again, let me turn this over to questions that you may have at this time. Will?
Stan, thank you so much. That was a lot of great information. So I just want to remind everybody, if you do have a question, please use the Q&A at the bottom of the screen, or if you want to put it in the chat, you certainly welcome to do so that we can address your questions. So then, let's see, let's get started with the questions. We did have a question that came in. Can you buy a house for rent as a C Corp?
Not well. You can do what you want, but you're not going to have the benefit of what I just said to you in terms of the value at the end of 5 years. It's because in order for the C Corp to fall within these parameters, it's got to be a true business that you're operating.
Excellent. Another question that came in. Can your financial advisors help with establishing a trust?
Well, the answer to that question is yes and no. That's a lawyer answer. And why do I say that? Because your financial advisor certainly is gifted in understanding how a trust operates, and they can explain to you what they believe should be in the trust. But they are powerless, California as elsewhere, because they're not attorneys. They can't draft that trust for you. So you have to go to an attorney. But again, you can make things simpler for the attorney by sitting down with a financial advisor and going through the elements that you feel need to be addressed. And again, I keep throwing this out because it's so common. When you have a second marriage, a trust becomes more important as to who gets what. And therefore, I think the financial advisor could set up a hierarchy of what should happen. And you take that to the attorney, and you could save a lot of effort and cost. So the attorney doesn't have to reinvent the wheel. But unfortunately, the financial advisor is powerless to actually draft a document for you to practice law as such, unfortunately.
Another question that came in. My mom bought a home with a boyfriend, not a husband. What's going to happen if one of them dies? My mom has 3 kids and her boyfriend has 2 kids.
You know, I'm laughing because that scenario I've been associated with Cetera for almost 29 years. That scenario we get called all the time on the same factual pattern, whether it be 3 children, etc. Here's the point. You have to start with understanding how the property is titled. If the property is titled as tenants in common, and what does that mean? It's fancy legal jargon to say the following. It means they're partners, so that on death of one of them, they can give their half share to whoever they wish to give it to, okay? If it's just a joint survivorship, and I should come back to that in a second and explain more about it, but in a joint survivorship, that good, bad, or indifferent, then on the first death, it would automatically go 100% to this, I say surviving spouse, to the other individual, in essence, taking out the children from the one that just died. In other words, so it matters how that title is. The danger in the example of a right of survivorship in that case is that the wishes of the one that died will not be followed. And that's really a problem, that clearly. So it matters how the property was taken. And regrettably, they probably didn't give much thought when they did this originally. But again, the only way that it would work in your scenario would be to make sure that property is now tenants in common, so that each 50% can go to whoever that person wants it to go to. Otherwise, it would go, as I say, to the wrong person or wrong group of people. So if it was done incorrectly before, it's something that certainly can be revisited while they're both alive, assuming they're both willing to sign off on it. Because otherwise, they're playing Russian roulette as to who dies first, if that's a good enough answer for you. And I might also add that, you know, I kept talking about wills and trusts and things like that. One of the ways you can avoid probate and everything else, if every asset that you own is driven by beneficiaries, then you avoid all this. Like if you have an IRA and you name a beneficiary, that IRA has nothing to do with probate, has nothing to do with your will. Just like an insurance policy, whoever the beneficiaries are, it goes to them. So it's out of their hands, so to speak. So technically, you could have beneficiaries of all your assets. You could have transfer on death, meaning that only when you die, as soon as you die, the asset goes to wherever. It depends how the account is set up. So there are other ways, and you can talk to your financial advisor for setting that up. But in your particular case, with the two sets of children and they're not being married, that is problematic. That definitely is a problem.
Question. Can you have a trust with a will embedded in it?
No, you could do the opposite. A trust could be set up as a provision of the will, but it can't work in reverse because a trust has to trump the will has to trump the trust, meaning that you have to have a will first, or no will. Everything could be in trust. But no, once you have a trust, then you wouldn't need a will in reality, because the trust would say what's supposed to happen. The will would not be needed at that point.
Mhm.
But again, a trust could be set up right now, irrevocable today in my lifetime, and it means it's a separate entity, or my will could delineate on my death to create a trust.
Okay. It's always best to talk to somebody who can help you answer those questions.
Absolutely. And
about
again,
whether-
I want to repeat what I said before about the circumstance where you had two people not married owning property. Boy, that's a recipe for disaster. And again, it's critical to talk to, I think you said your mother, as to how the property is titled. That's totally. And unless they had advice of counsel, it might have gone wrong, because the ones selling the house in escrow, they don't care. They just say, "Oh, do it jointly." That would be a mistake, in my opinion.
Yeah, and I think that's a lot more common than not. And I think people's situations are complicated, so they really need to get advice from somebody on what's the best action when passing down a legacy from generation to generation. Just because of the complexities of kids, adult children with other previous spouses and so on and so forth. So yeah, definitely get advice from an estate planning professional. Next question is, what is the best way to hold title on a rental property to protect your asset?
Well, that's asset protection is a tough nut to crack. The only way that an asset is protected from your creditors is if it's out of your estate. So effectively, you'd have to have the rental property owned by, and we said before, for different reasons, by a corporation, and therefore the asset would only be subject to the asset value, and it would not affect you personally. Let me give you an example. If I had a rental property and, which I owned in my name, and somehow magically the gas, caused the house to blow up. And it was determined to be, I was negligent because I didn't check whatever it may be. So not only would I lose the house, but I have a judgment against me for some horrendous amount of money. And typically the amount of insurance I had might not be enough. So the only way to protect my personal assets in that event is to limit the asset value only to the asset of that house, meaning that a corporation owns that house. So that only the value of that house is subject to that creditor. So the one that got hurt in the explosion could only reach the total value of the house, but not my personal account over your credit union or wherever else it may be.
Yeah, that's good. Another question came in. If my mother and I own a home that we live in and it's already paid off, both of our names are on the deed. My mother dies. Do I need to create a will or a trust? Any suggestions?
Well, again, it goes back to the question of how the title reads. I'm assuming in your case, it would have made sense to have the title such that it's the survivorship, meaning that I'm assuming that's the case. And if that's the case, you now just inherit 100% of the home. And so then the question is, what do you do? Then my next question of you would be, where do you want the home to go after your unfortunate demise? And no matter what age you may be, if you get hit by a car the next day, it can be sooner than later. So you never know. So you can't wait too long after the creation of 100% ownership to make a decision. So one way or the other, you either need to put that house in a trust. So the trust language says who gets the asset when you die, or at least in a will to say where it goes. Otherwise, like in California, if you don't have a trust or a will, then there's certain language of the probate code here in California that operates. It typically then goes to your children equally, and then if they're not around, it goes the parents if they were alive, and then cousins, etc. But you want to be clear as to where you want it to go to. So it's incumbent upon you certainly to do something as soon as you get ownership of the house, be it a trust or a will, either one.
Excellent. Someone's assembling her team of professionals for a detailed review of estate planning, protecting assets, reducing taxes for children, etc. Should I consult a financial advisor, a lawyer, or a CPA?
Let me say this to you. I've been a lawyer for well over 40 years. And my observation is, regrettably, especially in California, how do I say this? Lawyers may be very good in the law, but they, in my humble opinion, very few have the talent to truly understand the financial aspects of what they're suggesting. And so my point to you is, especially if it doesn't cost you anything at all, it is wise to first consult with your financial advisor to get their lay of the land. And then thereafter, hone down or narrow what the issues are that you want to talk to the lawyer, because the lawyer is going to charge you hourly for whatever they do. So don't, in my opinion, don't start with the lawyer, start with the gifted person who's giving you, they say, free advice, if you want to call it that. Certainly the financial advisor is integral. And I will tell you, as I say, I've been with Cetera 29 years, and I work with a lot of financial advisors all throughout the country. They are wonderful people, as are the financial advisors, certainly, and your credit union. That is the first place to go and listen to the recommendations that they make for you. That's what I would do.
Excellent. That's great. Great advice. Going back to the rental property, you said put in a corporation. Could you put it in an LLC?
Yes.
Okay.
Yes.
And then the mom living with the boyfriend owning the house. It is, if it's joint survivorship, should it be retitled as tenants in common or a trust? Should it be retitled
well, it wouldn't be a trust, because not to confuse you, you have two different people. And the trust could change. In my opinion, I wouldn't do a trust. I would absolutely do it as tenants in common. And again, tenants in common is nothing more than a partnership of those two people. And so one dies, that partnership interest, which is only 50% of the house, goes wherever it's supposed to go. Now, the challenge there would be whoever dies first in that arrangement, the one that survives wants to live in the house. And yet they live in the house, but the children from the first marriage end up owning the other half. And that's not a very workable arrangement. But that's an emotional problem. And I won't give you the name, but there's some, it's pretty funny to say this, there's some very significant movie star here in California that died several years ago. And they had some tremendous sprawling estate in Santa Barbara worth lots and lots of money. And I can't believe this. For as much money as they must have had, they apparently never went to a lawyer, because when they died, what they did was they gave half of the house to the children from the first marriage and the other half of the house to their surviving spouse. And there was all kinds of court litigation on that because the property was so large. Yes, they could each probably live in it and never see each other, but I mean, how stupid it really is. No lawyer ever would have suggested doing that way. But yeah, that's something that needs to be addressed sooner than later, for sure.
Absolutely. Okay. And let me just kind of, I know we had some questions in the chat. Let's see. Does a trust have to be recorded at the county clerk's office in California?
No. No.
Are there any situations where it would have to be recorded?
Well, going back, if you had the house in a trust, then you certainly have to have the title of that house showing that the trust owns it recorded. And you could just on your own record the trust. The trouble with doing that is if you record the trust, when you make changes thereto, you have to make sure that the county recorder has the most current trust. So I would not recommend that necessarily. There's really no true benefit in recording the trust document there, other than the fact you're concerned that somebody may, quote, lose the trust and say it's not there. You know, in other words, rip it up. You want to make sure that after your death, it shows up somewhere. And maybe there's an interest in somebody, you know, destroying the trust so that nobody knows it occurred. And you could alleviate that by really giving copies in advance of your death to your children or whatever. The trust would be notarized so it shows it's a valid document. But no, there's no necessarily benefit in recording the trust. If anything, it's a headache, in my opinion.
So, but are they public record?
There would be, if it's recorded, it would be a public record. That's correct.
Okay, but otherwise there's really no need.
There's really truly no. Again, your concern is you want to make sure the trust is found. In other words, if you go to the trouble of creating a trust today, you don't want it to disappear, and therefore, you know, somebody says, oh, they died with no trust. Well, and you can avoid that by giving a copy which is notarized to your children or whoever else it has. And if there ever was an issue, they say, hey, I've got this notarized document here. It was a trust. But if it never shows up anywhere, that's a problem.
Okay. So any successor trustee or let's say beneficiaries, is there a need to let them know ahead of time that they're beneficiaries, or can it happen at the time of death?
I guess it depends on the factual scenario of the family setting. And why do I say that? Because you may have 5 children, but you only have 4 children in the trust. I'm not so sure of answer my death that I would let the 4 know that they're beneficiaries and the 5th one say, I'm not. Because I'm joking when I say this. The 5th one may have you on Law and Order. I mean, you know, there'll be great hostility going forward. So if it's a negative consequence, you certainly don't want to make that aware to your children. And some people never tell the beneficiaries. That's your choice. It's no less no different than your IRA. You don't necessarily tell all of the beneficiaries who the beneficiaries of your IRA. Again, it's a choice, and some people may do it, some people may choose not to do it. Certainly when you have a family setting with children from a prior marriage, you know, you get to be iffy, and I joke about this, but you may very well, of your children, want to name all but one. You don't want to name them one for whatever reason it may be. And again, you don't want it to leak out, in my opinion.
Understood. So some of our younger employees over at the city of San Diego, is there what dollar amount or net worth is the rule of thumb for starting a trust?
There really is none. I would say that you want to trust when you have real property because it makes it easier to sell. Again, I use the example, forget the spouse. Let's say I'm a single individual. If my home, and I use this example, it happened to me with my parents. They had a condominium in Florida. And if it wasn't in a trust, and they lived in California, if it wasn't in a trust, that would have meant that we'd have to not only just have a probate proceeding in California, but we'd also have a mini probate proceeding in Florida, each of which would take 3 to 4 months, so that it could not be sold for 4 months. So when condominiums are all the same, unit number one is the same as unit number two, no one's gonna buy my unit number one if it takes 4 months before they get title. So the value of that on the market is greatly reduced. So you want to have real property certainly out of the state in a trust. But beyond that, there's no magical rule. It's not a dollar amount so much. It's an asset, whatever. And again, this is something that if you talk to a financial advisor, they can be more specific as to what your family history is and what your desires are and how it relates to you. But there's no dollar amount that makes it work and not work.
Okay. Another follow-up question or clarification on the rental house. LLC or S Corp, is one better than the other?
Not necessarily. No, it just depends how it's reported. An S Corp would end up being reported on your personal tax return. An LLC is a separate identity, which is, again, it's over there. It has a separate being. It pays taxes on, separately at those rates. But yeah, an S Corp, the benefit is it's all, on your tax return. It's good, bad, or different. I don't know. Depends what other assets you may have. And again, I'm saying this now, but this is something that your financial advisor is extremely conversant with. They see this day in and day out, thousands. I mean, they know well, and they give you many examples that are good and bad, etc. And you can make an informed decision based on that.
Okay. The question: when you create a trust, is that when you put down the beneficiary and when they receive the asset, like a house, and the timeline for when you die? Is that basically what it is?
Yes.
Okay.
A trust is looking forward, meaning that you put the asset in a trust, and then the trust document says, on my death, I can have the asset go immediately to those beneficiaries, or I could say the asset goes to the beneficiaries when they turn age 50 or whatever it may be. But that's right. The trust actually can have a full timeline, and there are many reasons why you do that. It may be that a house you give them outright, but yet money that's in the credit union, you might give them 20% on 1 year, 20% the next year, and you could just lay out a whole time period. And again, your financial advisor can work with you to what works best for you in terms of what you want to do.
Excellent,
so
excellent.
That's where a trust really can be very helpful. Yes.
And so the other spectrum of someone's kind of life journey, I plan on retiring in Europe. Will this affect my U.S. trust?
No, it doesn't affect the U.S. trust. It just makes it a little more complicated and convoluted, because they have to have somebody here watching over that. In other words, and not to confuse the hell out of you, but good, bad, or indifferent. And this doesn't get published much, but a U.S. citizen is taxed no matter where you have assets in the world. So the mere fact that I today moved to Spain and I have income, in a IRS standpoint, all that income that I earn in Spain is subject to U.S. tax. I may be paying Spanish tax, and I may get certain tax credits, but the mere fact that you leave the country doesn't really change the lay of the land vis-a-vis the IRS. So to your point, it doesn't really matter whether you leave the country and the asset is here or not. It just makes it more complex in dealing with whoever is running or managing the asset.
Perfect. And then in regards to future looking on a trust, how you want your assets to be distributed, can you set rules such as once your son finishes college, then you can get a distribution? Or does it have to be like, can you set those different milestones?
You could come up with 1,000 different things. The attorney may laugh at you. And again, it's really easy. The attorney just takes that list and drops it into a trust, but you're correct. And let me just say to you, when a trust is revocable, you could change that every day of the week, but the moment you die, you're locked in other words. So, and I joke about this. So if you're age 40 and you create a trust, you may feel a certain way about your child right now, but when it's 45, if the child becomes normal, if you want to call it that, you may change your mind and you may change that provision. But yes, absolutely, you can do anything you want, and that's the benefit of a trust. Yes.
Another interesting question. Do trusts also protect your future assets? For example, at the time you've written it up, you don't own a home, but then you plan on buying one in the future. Do you need to specify each asset that is protected, or can you just generalize it as to all assets owned by you?
The trust in Exhibit A would have the assets that make up the trust. And if the asset's not in the trust, it's not subject to the terms of the trust. So the problem is you have to make sure that if you sell a house tomorrow and then buy another one, you want to make sure that that new home is now listed as the asset of the trust. And let me tell you something else is a very common mistake, unfortunately. You know, a lot of attorneys run workshops to cause people to create trust, and they create a trust tomorrow. The problem is the attorney never sits down with the client to fund the trust, meaning to change the asset name to the name of the trust. In mere fact, I have a trust, and I don't have the asset names as part of the trust. I don't have a trust. I have a naked trust, but I don't have anything in the trust. So you got to be watchful of that in your own right. And let me just throw this one out here, and I laugh because it never happened to me. But, you know, people often say, do I need a will besides a trust? And my answer to you is as follows. If you had every asset today in trust, but you won the lottery tomorrow and then you died, that winning of the lottery would not be part of the trust because it wasn't in the trust. So you want the will to basically say, on my death, anything that I own in my name goes into the trust after that. So I joke about that. That's why you want the will to be a pour-over will, meaning that to be a catch-all to go into the trust. It may never be needed, but you want the will at least to say what I left out of naming in the trust directly goes into the trust. There may be an asset you just don't think about.
That's great advice. Question in regards to power of attorneys. Do power of attorneys need to be recorded at the county recorders?
No.
Are there situations where they would have
No.
to be?
The answer is no. It's just a question. I use the fraud word. People, you know, that's why power of attorney should be notarized, because we want to make sure that the person who gave it really signed it. And I will tell you that in the financial realm, much like your credit union, although power of attorneys can have an open-ended period of time, generally speaking, a lot of custodians say that they will not accept a power of attorney that's more than 5 or 7 years old, only because it becomes stale. They want a reaffirmation of the person that creates that to say they still agree with that. They don't want to see somebody misuse a power of attorney.
Excellent. Question about irrevocable trusts. What are the advantages of an irrevocable trust?
The only real advantage of an irrevocable trust is that it takes that asset today out of your estate, so it won't be subject to the estate tax valuation. But again, it probably has less meaning today than it did many years ago, because that federal estate number, and especially California, does not have a state estate tax. So if you have below that number, there's no benefit of removing it from your estate, because it grows in the hands of whoever is the, gets it after. But yeah, there may not be an advantage any longer right now. And I say this in a jocular sense, and it's not a political statement. You know, a lot of these provisions that were signed in July claim they're permanent. I'm telling you, over my lifetime, with different administrations working for the IRS, nothing is permanent. Permanent is only as good as the next Congress meets. So you don't know what's going to happen in the future. Nobody has a crystal ball.
Absolutely. Now, people, as time goes on, they'll make amendments, changes to their trust. Do you have to retitle the trust every time you make an update?
No. You really, no. The update is typically only to the assets in it. Like I keep saying, Exhibit A. So Exhibit A starts out with 2 items named in the trust. But if you create a new asset, you now then amend the trust, or just amend, Exhibit A to include a 3rd element. It's only that last exhibit, and frankly, you could do that on your own. That's not it's not rocket scientist.
Okay.
You're not really changing the trust. You're just adding modification to the assets that are within that trust. But again, if you leave nothing else, it's absolutely imperative that not only do you have to have a trust, but the trust must have the assets named as part of the trust. Otherwise, you own no trust. I mean, if you don't name it in the trust, it doesn't exist.
Okay.
For the trust purposes.
Excellent. Now, does the name of the trust in either spouse make a difference in its power?
No. You can name the trust any way you want. I can name my trust the Will Rivera Trust, and it could be my trust, but I just use his name. I'm joking. I'm kidding. I mean, but the name of the trust is not significant. I mean, you can name it anything you want.
Usually those names will have trust dated in a certain date. Is that part of the title or the name, or?
Not necessarily, no.
Okay.
No, the answer is no. You do it for identification purposes. I joke about that, but so you want to make it clear to somebody else what it really involves. And I kid when I say my trust can have Will's name on it. I wouldn't want to do that because anybody looking at it would think it's Will's trust, but only when
Right.
they got to the signature block when they realize it's my trust. So no,
Mhm.
you want to be consistent.
Okay, so our last question, so the example you gave about Spain, this particular attendee will be actually retiring in Spain and it was confused about the tax answer. So regarding the taxes, if you have income in Spain, are you going to be taxed in Spain as well as the
Yes,
US?
the answer is yes. And then what happens is the US has treaties with various countries, and the treaties, and certainly Spain and most of the European countries, if you pay tax in Spain, you get that as a credit on your federal income tax here. It just means you have to pay your accountant much more money to file a more complicated tax return. But no, the answer is you're not going to pay tax twice. It's just that you do have to declare the US money. But I hate to say this. I think a lot of people permanently living overseas probably never file the US tax return, and that's wrong. That's dead bang wrong. But yeah.
Good advice. Good advice. Stan, that was amazing. Thank you so much